So Judge Juan Merchan just responded in the Manhattan District Attorney criminal case against Donald Trump after this flurry of letters where the Manhattan District Attorney talked about how 31,000 documents were just turned over by the United States Attorney's Office. And the Manhattan District Attorney had consented to a 30-day adjournment of the trial. Then Trump's lawyers responded and basically said there needs to be an immediate adjournment, an immediate dismissal, and basically delay this trial at least 90 days or much further than that. And after a back and forth, Judge Merchan responded immediately. He set a hearing for March 25th, 2024 on the issue of this production of documents by the United States Attorney's Office, the Department of Justice. And he also stated that there would be a 30-day adjournment of the trial for now, which brings us to about mid-April. And then at the March 25th hearing, Judge Merchan would assess the trial date, whether that new trial date in mid-April is appropriate, probably fall on April 14th, 15th, around that time period, or whether a later trial date would be appropriate. But I guess the headline for now, which we said was going to happen, is that the March 25th, 2024 trial date is no more. There's at least a 30-day adjournment from today, from the date of this letter by Judge Merchan. But it looks like Judge Merchan is keeping a tight leash on this case. Karen Friedman-Agnifilo, the former number 2 at the Manhattan District Attorney's Office. You know the inner workings of that office. You know Judge Merchan and what he's likely contemplating here. What do you make of all of this?
So I read this letter as he's pissed, right? He was ready to go come hell or high water, March 25th. He knew that Trump was going to try to delay this, and Trump was going to pull out every single stop he could possibly pull out. We all were thinking, what are the ways he could possibly try and delay it? Ben, your way seemed to be the most likely, the one you predicted, which was that he was going to file, the presidential immunity issue. Nobody could have predicted what happened here, and that all of a sudden the United States Attorney's Office for the Southern District of New York, or SDNY as we would shorthand it, no one would have thought that it would have been them causing the delay by doing a giant, massive data dump and document dump on the eve of trial that is causing a delay. That is just very, very surprising and shocking, actually. And to see that, that's happening is just, you could tell that Judge Merchan is just shaking his head, thinking, "How is this? Why do I have to be dealing with this now? How could you have let this happen?" And so he set a hearing, and the title of the hearing should be, "How could you let this happen, and what happened?" And so he feels that he doesn't understand, because this is what the Southern District did by dumping literally 75,000 documents on the Manhattan DA's office on the eve of trial is absolutely outrageous, because it derails the case like it has. And so the judge is going to have a hearing to find out what happened, because I will tell you right now, discovery violations are taken very, very seriously. And if it turns out that the Manhattan DA's office did something wrong, the judge has wide discretion on what he can do. And the remedy could be dismissal of the charges. It could be all sorts of things. Now, he's not going to do that, because I'm fairly certain that this is not going to have anything to do with the Manhattan DA's office, right? They asked for this information over a year ago, and the Southern District didn't give it to them, and nor could the DA's office force them to do it, because there's something called the Supremacy Clause in the United States Constitution, which means the federal government trumps the states. That's just the way it is. And so although the federal government could subpoena a state prosecutor and require them, they could actually just require them to turn their evidence over. State court prosecutors can't do the same to the feds. And it's just sort of a very interesting quirk of state federalism, frankly. And so he's going to hold a hearing to find out what happened. And you're going to see someone from the Southern District is going to have to testify. I know that they're probably going to fight it. They're not going to want to testify, but they're going to have to put someone on the stand, I think, to explain exactly what happened and why. And so in our world, that's shots fired, right? No one from the Southern District is going to want to have to take the stand and testify at this hearing and have to explain why they refused to give this stuff over to the Manhattan DA's office in the first instance, and then only later gave it over after Trump subpoenaed it. Now, so Judge Merchan in this 3-page letter goes through the various dates of, the defendant filed a motion seeking permission to file another motion. And then on another date, the people responded, and goes back and forth, back and forth, back and forth. And then on page 3, he says, in light of these recent developments and delays occasioned thereby, there is no prejudice to the defendant in granting the people's request to extend their deadline to respond to a motion by 3 days. And likewise, there's no prejudice to defendant in granting the people's motion to extend the deadline to finalize the trial exhibit to the March 25th. The court stresses that the hearing will be limited to the specific issue of defendant's motion to dismiss on the grounds that the people alleged discovery violations related to the production of records by the U.S. Attorney's Office, Southern District, New York only. Likewise, the timeline and accompanying documents produced to this court shall not include documents or records constituting discovery unless a particular record is necessary to resolve a factual dispute. And so he's basically saying we're having a hearing, and the hearing is only going to be about this discovery violation, because he also goes on to say, as evidenced by defendant's most recent letter filed this afternoon, there are significant questions of fact which this court must resolve before it can rule on defendant's motion. Therefore, the court agrees with the defendant that a prompt hearing is required on the pending discovery motion, the circumstances surrounding the document production by the U.S. Attorney's Office, Southern District, New York, and the scheduling of a trial date if one is necessary. So what Judge Merchan is saying there is, I'm adjourning the trial date for 30 days from the date of this letter, which I think is going to be April 14th or 15th. And then they're going to have a hearing, and it's at that hearing that they'll determine how much time is needed to go to trial, or should we just have the trial then?
Yep, and you have April 14th is the Sunday, so April 15th, that Monday would probably be the date. And one of the things that Judge Merchan is directing the parties to do is to, and you see this on page 3, is to separately furnish to this court not later than Thursday, March 21st, a detailed timeline of all of the events surrounding the requests and ultimate production of documents by the United States Attorney's Office from the Southern District of New York that serve as the basis of the People's March 14th, 2024 letter. That's the letter where the district attorney said, we just got these 31,000 records. The timeline should be accompanied by all correspondence between and among the district, the DANY, the Southern District of the District Attorney for New York, with the lawyers from the United States Attorney's Office from the Southern District of New York, that goes, so with the DA and with the feds, that goes to the subject of the defendant's motion, and which is covered by the People's Notice of March 14, 2024. The correspondence must include, but be not limited to, letters, subpoenas, emails, notes, messages, etc. The requested documents are necessary for this court to properly assess who, if anyone, is at fault for the late production of documents, what prejudice, if any, was suffered by either party, and what sanctions, if any, are appropriate. And as you go, a little bit earlier in the letter as well, I mean, Karen, this is not a small group of documents or a small number of documents. I mean, as the court outlines and as we've discussed in prior duets, I mean, you're talking about 73,000 pages of records on March 4th, 2024. You're talking about 31,000 pages of records on March 13th, 2024. And then we're talking about another 15,000 records that were expected to be produced today. That's a lot of records. And I know you were the number 2 at the Manhattan District Attorney's Office. You're also now in private practice as a criminal defense lawyer. And, despite both you and I think vehemently believing that Donald Trump should be brought to justice. I think you and I also believe in the system of discovery. Criminal defendant, regardless of if your name is Trump, is entitled to have the discovery produced to them, so long as it's requested within the right periods of time. And I know that Trump's lawyers requested it later than people would have liked, but it was still within the deadlines of when the request was made, January of 2024. And so Trump's entitled to at least review this. And I don't think Judge Merchan's going to in any way allow Trump to do any of these gimmicks or any of these stunts to try to delay trial like absolute immunity. Merchan's not going to stand for that. But, this is a pretty kind of basic fundamental issue when it comes to discovery. And I think Merchan is doing the right thing here. Everybody give me everything that happened over the past year. Show me the subpoenas, show me the emails, show me the timeline. Let me understand what happened here and how this could have happened. And then I'll be informed to make the appropriate order. You and I talked about how the district attorney was very confident in their letter that it wasn't their fault, that they requested this a year ago. The factual disputes in Trump's letter that it's been a day of a lot of news. The Trump's lawyer says, no, maybe the DA requested it, but the DA didn't technically follow up with some of the other forms that they could have followed up with, I think was one of the arguments from Todd Blanche, Trump's lawyer. So I think the court's saying, let me get to the heart of this issue and what's going on here. Karen, I'll give you the final word.
Yeah, look, hopefully it doesn't turn out that this is something that can be put on the Manhattan DA's office, because that would be, I think, stunning and difficult to recover from. But, I just want to say one thing. Yes, it's 73,000 records, but back in the day before things were electronic, and they would hand over piles of paper, it was never that great of discovery. It was never that much. And sometimes it would be if it was a big document heavy case, you'd have to pour through them and it would take forever, right? You'd pour through documents and documents and documents and you'd have to review them. And it could take a very, very long period of time. But this is now in electronic form. And every case has lots and lots of records now, because emails come, there's this whole thing when you send emails of, there's the prior emails and then the reply emails and then those replies, et cetera. And that can make it seem like there's more records than there actually are, number one. Number two, it's much easier to search through records and find ones that are relevant now, because you can do electronic searches on these discovery platforms. And that's what every single practitioner does now. That's standard in discovery review, which is you get all this stuff electronically and you actually turn it over to the defense electronically as well. You don't hand them a pile of 73,000 records. And they look for search terms that will then highlight things that are relevant to this case. So let's say they want anything that has to do with Michael Cohen, because Michael Cohen was prosecuted by the Southern District for the allegations here. So all they have to do is put in Michael Cohen, and every record that has to do with Michael Cohen is in there. And some of them will be duplicates. And so there's this process called deduping that they will have to do to get rid of the duplicates and really pare it down to what's relevant for this case. I think that you're going to find there isn't a lot, because the investigations are sprawling. There's no stone that goes unturned. And this is a very limited case involving 17 payments to, or actually no, 11 payments to Stormy Daniels from, by way of Michael Cohen, and then false entries related to each one of those payments. And it's a much more limited case from the one that the Southern District was looking into involving Michael Cohen. So you're not going to have 73,000 documents that are relevant to this case, nor are you going to have, I think, any earth-shattering, anything that's going to be Brady or exculpatory. But if you do, that's all going to come out, and that's going to come out in the hearing. But the only final word I will leave you with is it's very clear to me that Judge Merchan saw the Judge McAfee, Fani Willis hearing that went so far afield from what was relevant there that he made sure to punctuate this letter by saying, this hearing that's going to happen is only to determine this the factual dispute in this discovery dispute, because he wants to make sure that it's not some sprawling hearing on other matters and other extraneous factors. And let's get this trial going.
It's a great point. It's actually what Judge Scott McAfee should have done. Send me your list. Send me your list. Identify the conflict. Let's be surgical about this and not just open it up. And you really see, it's a great point. You see the distinction right there of how Mershon is handling this versus how McAfee handled this, which I think is good news to just getting to the bottom of this issue and not turning this into a circus. Ben Meiselas and Karen Friedman-Agnifilo from Legal AF here giving you all the breaking news updates. Make sure you subscribe to the Legal AF audio podcast wherever it's available, and hit subscribe on our YouTube channel as we're getting close to that 3 million subscriber mark. And thanks for watching.
Hey, Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.